the next case set for argument this morning is Pursuit Commercial Door Solutions versus Moosally Construction Inc. It's case number 29157. Both parties are represented by counsel this morning, so each side will have 15 minutes to present your arguments. Pursuit, you're the appellant, so you may reserve up to 5 minutes of your time for rebuttal. If you choose to do so, let me know. There is the clock on the wall, but I'll also try to remind you as you get close to that point. The court has read all the briefs and everything submitted in this case, so we are ready to proceed if you are.
Thank you, Your Honor. Thank you, Your Honors. May it please the court, my name is Mike Fortney and I represent Pursuit Commercial Door Solutions. I would like to reserve 3 minutes of my time for rebuttal.
Again, I'll try to remind you to keep an eye on the clock.
Certainly. Your Honors, this case is about a mechanics lien on a commercial construction project and provisions of the mechanics lien law that relate specifically to commercial construction projects. The appellee, Rose Group, is going to discuss case law that relates to mechanics liens on home construction projects. It is going to try to make you believe that those cases apply to commercial construction projects as well. But these cases do not apply, and this one-size-fits-all approach goes against Section 1311 of the Revised Code. All Pursuit asks of you today is that you interpret the mechanics lien law as written, nothing more. Rose is asking you to fundamentally change the commercial construction statute by using a separate provision of the mechanics lien that does not apply. The lien law, Section 1311 of the Revised Code, protects subcontractors who perform work on construction projects. If contractors are not paid for work performed on the project, the mechanics lien law allows them to file a mechanics lien against the owner's interest in the property. The lien law treats liens for home construction projects differently than commercial construction projects. Home construction projects are governed by Section 1311.011 of the Revised Code, whereas commercial construction projects are governed by Sections 1311.02 to 22 of the Revised Code. In fact, the sections of the mechanics lien law at issue today, Section 1311.04 dealing with notices of commencement, and Section 1311.05 dealing with notices of furnishing, both specifically and explicitly exclude home construction contracts from their purview. Section 1311.040 specifically states, this section does not apply to a home construction contract as defined in Section 1311.011 of the Revised Code. And Section 1311.05e states, this section does not apply to any improvement made pursuant to a home construction contract as defined in Section 1311.011 of the Revised Code. A subcontractor on a home construction project is not required to serve a notice of furnishing. In fact, Section 1311.011 does not even mention the word furnishing. The commercial construction sections of the mechanics lien law do deal with notices of furnishing, as described in Section 1311.05. If an owner records a notice of commencement pursuant to 1311.04, then a subcontractor is required to serve a notice of furnishing in accordance with Section 1311.05 in order to preserve and protect its right to lien the property at some point in the future. The sole issue presented for review today is whether the trial court erred when it dismissed Pursuit's mechanics lien for the sole reason that Pursuit served its notice of furnishing after the notice of commencement was recorded by Rose, but prior to beginning work on the project. The question for this court is simple. On a commercial construction project, does a subcontractor properly preserve its mechanics lien rights when it serves a notice of furnishing after the recording of a notice of commencement, but before beginning work on the project? The trial court, relying on inapplicable case law related to home construction contracts, determined that Pursuit's notice of furnishing served in that fashion did not preserve its lien rights. Specifically, the court said, it is undisputed that Pursuit served the notice of furnishing before performing any labor or work or furnishing any materials for the project. A notice served prior to delivery of materials does not provide proper notice of a mechanics lien. However, when we analyze the statute in question and the case law relied on by the trial court, it's apparent that a notice of furnishing served prior to beginning work, but after the recording of the notice of commencement, does preserve mechanics lien rights.
So by right and Moosally did not specifically limit themselves to home construction projects.
The by right case, a case from this court, did limit it to 1311.011. It was the Halsey court that took things a step further and attempted to fit 1311.05, the notice of furnishing statute for commercial construction projects, within the confines of the by right holding. And in order to do that, the Halsey court deleted very pertinent language from 1311.05. 1311.05 states that a notice of furnishing must be served by the subcontractor, quote, at any time after the recording of the notice of commencement, but within 21 days after performing the first labor or work or furnishing the first materials, end quote. The Halsey court deleted the first clause of that section. The Halsey court deleted the at any time after the recording of the notice of commencement language. What the Halsey court was then left with was the language that says, but within 21 days after performing the first labor or work or furnishing the first materials. In this situation, the trial court felt compelled by the Halsey decision and the by right decision to make the determination that a subcontractor serving a notice of furnishing pursuant to 1311.05 must only serve that notice in the window starting with the first day of work on the project and ending with the date 21 days after the first day of work. That is not what 1311.05 says. Instead, 1311.05 says that a notice of furnishing must be served at any time after the recording of the notice of commencement, but within 21 days after performing
So
the
what's
first.
the purpose, what's the legislature intending there? What's the purpose of that statute?
Well, the purpose of the notice of furnishing statute is a protection for owners who undertake construction projects. An owner undertaking a commercial construction project can, but is not obligated to, but it can record a notice of commencement pursuant to 1311.04. If the owner records that notice of commencement, then that places an obligation on suppliers, subcontractors, and other contractors who wish to preserve their lien rights. If those subcontractors wish to preserve those rights, they must file a note or serve a notice of furnishing in accordance with 1311.05. If they do not serve that notice in accordance with 1311.05, they do not preserve any mechanics lien rights as it relates to that project that the notice of commencement was recorded on. So I would say that the notice of commencement statute is a protection for owners, and the lien law in general is a protection for subcontractors. So the notice of commencement and notice of furnishing statutes just place one additional requirement on subcontractors in order to protect themselves and avail themselves of their lien rights.
So there is some interplay between the notice of commencement statute and the notice of furnishing statute.
Absolutely, yes. The notice of commencement is the precursor. The notice of furnishing statute states, I'm going to look it up right here. If a notice of commencement, no subcontractor or material supplier who performs labor or work must serve a notice of furnishing where an owner fails to record a notice of commencement. That's section H of 1311.05. So yes, the notice of commencement is a precursor to the requirement to serve a notice of furnishing. And as I said, the by right case, a case from this district, the by right court did not analyze 1311.05, nor should it. The by right case and the Halsey case both deal with home construction, not commercial construction. Two separate sections of the lien law, two separate and distinct forms of construction according to the lien law. The Halsey court is the court that went above and beyond and began interpreting 131105, something it had no business doing. And what's worse, as I said, when it interpreted 131105, it deleted very pertinent information from the statute. This fundamentally altered the statute. And as this court knows, when interpreting statutes, the statutes are to be interpreted as written. Deleting language from a statute fundamentally changes it. So because of the Halsey decision, the trial court felt that the only window to serve a notice of furnishing for a subcontractor was the window, as I said, 21 days from the date of the start of work until the date 21 days later, a minuscule 21-day window. On this case, the trial court found that Gross recorded its notice of commencement on May 6, 2015. 131105 states that a notice of furnishing shall be served at any time after the recording of the notice of commencement. Notice of commencement was recorded May 6, 2015. Thus, the earliest date that Pursuit could have served its notice of furnishing was May 6, 2015. The trial court also found that Pursuit's first day of work on the project was October 17, 2015. 131105 states that a notice of furnishing must be served at any time after the recording of the notice of commencement, but within 21 days after performing the first work. The first work was performed October 17th. 21 days after that is November 7th, 2015. Thus, Pursuit, according to 131105, had from May 6, 2015 until November 7th, 2015 to serve its notice of furnishing. The trial court held that Pursuit served its notice of furnishing on September 10th, 2015. September 10th falls squarely within May 6th and November 7th. So according to the written words of 131105, without deleting words, Pursuit properly served its notice of furnishing in accordance with the statute. So today, Pursuit asks that you reverse the trial court's decision and declare that Pursuit's notice of furnishing was properly served in accordance with 131105 and remand this case for further proceedings consistent with that opinion.
Quickly, is there any case law precedent that supports your interpretation of the statute?
As far as I know, there are no cases dealing with the interpretation of 131105 in this scenario. The two main cases are the Byright and Halsey cases, but as I said, they both deal with home construction.
All right, we'll reserve then 305 for you.
Thank you.
303, actually. Counsel, you'll have 15 minutes then.
Thank you, Your Honor. May it please the court, I'm Mike Stabnicki. I represent ROCE Group, not ROCE, ROCE, it's like USA. This case is simple, and the court simply needs to follow the law. While the appellants make a series of, ever dramatic and changing arguments between the trial court and here, they lose under the law, they lose under the facts, they lose under their admissions, and they lose under their conduct. ROCE was building a hotel in Stowe, and to put it lightly, the construction project was a nightmare of epic proportions. Bankrupt contractors, contractors taken off, materials not delivered, doors that wouldn't open, elevator shafts filled with water that were identified by an inspector as a life safety hazard. The contractors were dramatically late in hitting the schedule. The project started in 14 or 15. It was supposed to be done by February of 16, so they could hit the summer season of 16. And as we all know, in the greater Cleveland area and Akron, summer of 16 would have been a great time to have your hotel open because you had the NBA Finals, the Republican National Convention, and the parade, plus just the summer season in general. Missed it all. Pursuit, as opposing counsel said, ROCE filed its notice of commencement in May of 15. They attempted to serve an alleged, I'm going to use the word alleged a lot, notice of furnishing in September of 2015. It admittedly never did any work or showed up on the job until late October of 2015. They then, to add insult to injury, filed a lien, filed a lawsuit, hadn't paid other subs that they claimed that they had paid, including Oshkosh, so we got sued by a bunch of people. The decision of the trial court was proper, and I'm going to walk you through that, but really what you need to look at in this case, it's kind of like 4 main points why, and I kind of glom them all together. The notice of furnishing, the lien, the lawsuit, were all improper. Number 1, the notice of furnishing was not timely. Number 2, the notice of furnishing was never served. Number 3, the work relating to the lien and the materials relating to the lien were never delivered or performed. So we got a phantom lien. And maybe most tellingly, the alleged notice of furnishing isn't a notice of furnishing at all. If you look at the attachment to the motion for summary judgment, it's a Florida form called a preliminary notice. Don't know what that is, but that's not a notice of furnishing in Ohio. So let's deal with the notice of furnishing being untimely. Opposing counsel takes this window, and they've argued repeatedly, I think in the briefs and in the trial court level that...
Before you go there, did
Yeah.
the court, in its ruling, state that it wasn't served properly, state that it was not a preliminary notice, or did it just rely on the timeliness and on the case law that was cited?
I think it kind of went with the first thing up, which was the first way out, which was just that it was untimely. It touched on service, and there was a reference to like the attempts at service, but it based its decision on the timeliness issue.
Okay, I'm sorry to interrupt you.
No problem. What opposing counsel argues is that you've got this window at any time after the notice of commencement and within 21 days for them to do a notice of furnishing. Wrong. Someone please tell me how the words at the end of that sentence that they ignore, but within 21 days after beginning service, include a period before you've ever delivered materials or ever done work. That is not within 21 days of work, it's months earlier, or about 7 weeks earlier. That is not within 21 days. So while they claim that that these other decisions delete the first part of the sentence, they're deleting the second part of the sentence because it doesn't fit their story. But within 21 days of doing work. If I don't do work until the end of October, and I serve my notice of furnishing in September, I am not within 21 days of doing work.
Well,
Go
but you
ahead.
could interpret that to, as they're saying, to be that period. I don't think they're saying that it's not applicable, they're just, or ignoring it, they're just saying that it's any time after the notice of commencement until the time that they actually furnish the materials and start to work at 21 days afterwards. So
Yeah,
there's nothing in statute that says that you can't file beforehand.
There is. It's but within 21 days of doing work. So if we're saying that you can serve a notice of furnishing 2 years, let's assume you're the roofing contractor, the painting contractor, somebody that's at the end of a job. Cleveland Clinic's doing a giant hospital, it's going to take them 5 years to build. They serve a notice of commencement on day number 1 because you're going to be doing work 5 years later. You give them a notice of furnishing. That isn't within 21 days of doing work. I understand the theoretical concept of, well, we're doing the work, but that's not what the statute says. The statute doesn't say, at any point after the notice of commencement, you may serve a notice of furnishing. It says, there's 2 requirements. If a notice of commencement is filed, you have to do a notice of furnishing, and it must be within 21 days of doing your work. Doing it before puts the cart before the horse, because you haven't begun doing your work. They're ignoring the but within, and it's the within language that I have an issue with them.
Of course, the statute also could have said, shall record the notice of furnishing at the commencement, at the beginning of furnishing the work,
Correct.
and no later than 21 days after.
Again, yeah, the legislature could always make it easier on us. They never seem to do that. There's clearly ways they could have written it that would be easier for you in my way or easier for you in their way. The way that I look at it is, it does not say, if a notice of commencement is filed, you may serve the notice of furnishing at any time thereafter, but you only preserve your lien rights for the 21 days before that if you've already started work. That's not what it says. That's what they're trying to spin it to be, and I disagree with that. Let me touch quickly on the 2 cases so I can move into the other issues. They're right that by right deals with a home construction case, but I don't look at the by right case for the issues of the specific language of the statute. What by right was significant on is that there's something for home construction cases, which is a different type of notice. And what Byright and this court was saying on that is, it's kind of like analogous language, which was, we can't go outside the statute. You can't do it before you've done the work because it defeats the notice purpose. The same concept applies here. Halsey takes it all the way, and while they claim it's a home construction case, it is directly dealing with a notice of furnishing and the language in the statute, and says the exact same thing, which is, you don't have a right to serve a notice of furnishing before you've ever shown up on the job. This mirrors and goes along with what I would argue is the entire purpose of a notice of furnishing. Why does an owner want a notice of furnishing? You want to know who's on the job, actually doing work. I don't care who's coming on the job 4 years from now, because that may get fired. The sub who hired that material man may get fired or go bankrupt. I need to know who is present on the job, actually doing work. That's the way you can run through your construction budget. You can check with your generals, you can check with the trade subs that relate to that line to figure out, hey, wait a second, is Pursuit getting paid? Pursuit's not even on the job, why am I even looking at them? That's the purpose of the statute, to be able to structure, budget, and coordinate who's on the job to assure that those people are getting paid, or that they're not getting paid, or is there a problem with the work? Is the work deficient? Should there be withholding or retention for the work because they didn't do the work?
Aren't those issues of whether or not the lien amount is valid, and isn't this a notice preservation statute?
It is, I'm sorry, go ahead.
But I just, let's say I had a $100,000 contract, and I started and I put $10,000 worth of effort into the job, and the day after I filed my notice, the day after I started.
Mhm.
Where's the import of not having filed it before? Because if my lien rights are going to be determined on whether the lien is valid, how much I've done with the job up until that point, 10 days after, 1 day after, maybe not. But so, is it really valid in terms of the budgeting, or is it just a notice statute?
No, I mean, from doing a lot of construction law, I would say that you want to know, and I know the developers and builders, owners want to know who is on the job, because you've got to be able to track it. And I see what you're saying with regard to budgeting or with regards to problems on the job, so I don't want to overspeak it, but we have a notice of furnishing from Pursuit. Pursuit has claimed they're on the job doing doors. We can go to the job and see, are there doors there? Or are there problems with the doors? Someone telling me 2 months, 2 years, under their argument, 10 years before they actually show up on the job, they're going to do it, defeats the entire concept. And I'm going to be running out of time, so I hope that answered it. Let me spin through some other things. Real quickly, the notice of furnishing was never served. Again, it's referenced in passing and kind of like glossed over by the trial court because they didn't need to get there. And they admit on page 2 of the brief of the appellant and in their deposition that it was never served. Turning quickly to my third issue, and this is very troublesome for me, which is the work that relates to the mechanics lien, that relates to this defective notice of furnishing, wasn't done. So we've got a phantom notice of furnishing that's too early for work on a mechanics lien that was not done. Appellant admitted in the deposition, admitted in their briefs, and we cite to this in our brief, doors weren't provided, hardware wasn't installed, bathroom fixtures weren't done. And if you look at what was going on, Pursuit found out, appellant found out that Moosally, this bad guy general contractor that they were hired by, we didn't hire them, was having problems. And they said, we demand prepayment before we go on the job and do this work. That's the number that relates to this lien. Product wasn't given, the work wasn't done. It's a defective NOF on a lien that's fraudulent and false on its face, which is why we had a slander of title counterclaim, but after the case was resolved, we decided not to go forward with it because where are you going to go with that now that the hotel is open? But that is a massive problem. This is a false lien. They admitted in their deposition, that work wasn't done. So what are we dealing with? Finally, and kind of most disturbingly, if you look at the notice of furnishing, that the document that they claim is a notice of furnishing. It's this thing. That's not a notice of furnishing.
Is it consistent with the statutory?
No.
It's
No. It doesn't say notice of furnishing. It cites to Florida law because Pursuit is out of Florida. It says preliminary notice to owner. There is no such thing as a preliminary notice to owner under Ohio law on a commercial job. I don't know what this is. It doesn't have the warning language in the statute. This is what the statute requires. Notice of furnishing, specified sections. Bottom, warning to owner. This notice is required by Ohio's mechanics lien law. It's not on this, because this is a Florida form. So not only do we not have a timely notice of furnishing, not only do we not have service of the notice of furnishing, not only do we have a false lien, because they admitted they didn't do the work because they were demanding prepayment from this bad guy contractor who they were engaged by, we didn't hire them. They use a form out of Florida. Now, I'd be remiss if I didn't touch on the issue that they raised in the reply briefs, because I don't get to do a surreply. They addressed the issue saying, no. Hey, Court of Appeals, avert your eyes from service. Avert your eyes from the fact that the mechanics lien relates to work that in a deposition we admitted we didn't do. Ignore all that stuff, that the form isn't right, because the trial court based its decision solely on the timeliness issue. Wrong. Wrong. What the Ohio Supreme Court, what this court have always held, is that, let's assume a trial court gets a decision, makes a decision, the decision's right, but the logic and reasoning and basis for that decision is all over the place and wrong. And I'm not saying that this trial court's decision is wrong, but I'm saying that there is a mass of ways, a variety of different ways that the trial court could have ruled on this. But if the decision of the trial court is right, but the reasoning for the trial court's decision is incorrect, the Court of Appeals has to still affirm, because it's harmless error.
Well, but we've said the exact opposite in our case law, haven't we?
No.
It's not yet. Oh, I think we have. We can look, we won't debate that.
It's okay. I presume that you would know it better than me, but the case that I saw from this court was Cook Family Investments versus Billings. And then there's a Ohio Supreme Court case law on it, which says if the decision is valid, but they got there in a way that this court wouldn't do it, or in a different way, if it's harmless error, especially in a civil context where it's not a criminal context, go ahead.
Well, the thing is, though, that's dealing with the analysis. This court didn't even look at those particular issues.
Well, I would respect.
I guess we're talking maybe the same thing, but just differently. Because the point is here, you say this is not valid, this is not all these things, but the court said, well, I'm not even gonna go there because it's not timely.
She did, yeah, the trial court
So
didn't
she
have.
hasn't even engaged anything in it.
But all of those issues were briefed, and you're right.
Is that
you know,
we'd be acting as a trial court, wouldn't we?
Yeah. No, I don't think so, because again, is it harmless error? Is there anything that happened to them? Because all of those issues were briefed. The trial court, you know, just like dealing with the statute of limitations, well, I don't have to deal with the liability and the negligence because you don't even pass the first step. Got to the first step and kind of stopped. But again, if you look at the documents, you'll see that remanding it back, not affirming the trial court, is simply going to end up in the exact same result in the exact same place. And again, I also think the trial court made the right decision based on the but within 21 days issue.
All right, thank you for your argument.
Thank you,
For your time. You've got 3 minutes, a little over 3 minutes for your rebuttal.
Great, thank you, Your Honors. I would first like to address what Judge Carr was addressing, and that are the last 5 minutes of Rose's argument centered on facts that were not determined by the trial court. The trial court did not determine any of the issues related to work performed on the contract because, as Judge Carr said, the trial court did not get there. It said Pursuit's notice of furnishing was served prematurely, therefore Pursuit does not have a mechanics lien, therefore we don't need to get into any of those other issues. So those issues raised by Rose are not right and not germane to this appeal. Now, getting into Rose's other arguments, the distinction, and I think this is what Judge Hensel was getting at, between a notice and a mechanics lien is a big one. We're talking about a notice of furnishing, which is just a document to put the owner on notice that work is being performed or is going to be performed on the project. That's all it is. It's a notice. Pursuit, when it serves its notice on September 10th prior to commencing work, it doesn't have any lien rights. It admits that it doesn't have any lien rights at that time. Its lien rights accrue at some time later after it begins work on the project, and that's the only time that it can actually record a mechanics lien against the property. So Rose is attempting to make the argument, I think, that the notice is akin to a mechanics lien and can actually damage the property, you know, a lien against the property. It's not. It's simply a notice saying, here we are, we're out here, we're under contract with the general contractor, you should know about us, we may file a lien in the future if we're not paid, which is exactly what happened here. And then regarding the argument that the notice of furnishing was A, in not the proper form, and B, not properly served, the trial court, in its findings of facts, says the court finds the following facts are not in dispute. Rose Pursuit attempted to serve a notice of furnishing on Rose at 4170 Steeles Point address on September 10th, 2015. Revised Code 1311-19, the service statute, states that if the service is attempted upon an owner at the address contained in the notice of commencement, service is complete when first attempted. Therefore, service is complete on September 10th, as the trial court found. Further, regarding the form of the notice, Rose made a big deal about the form, but 1311-05 provides a form notice and says that a notice of furnishing must be in substantially the following form. It doesn't require that the notice be in that precise form using that precise language. Thank you.
Time as well. Thank you both for your arguments. Court will also take this matter under advisement. We will render our decision, and you will get a copy of the court's decision on the day it's released. You can also check the Supreme Court of Ohio's website, which where the opinion will also appear.
Thank you.